All right, good afternoon. We're on the record today now for the 28th Circuit Court here in Wexford County. We don't have much to do today, but we're going to take up a case called People of the State of Michigan versus Tanya Leebrown. And while this is the 28th Circuit Court, and I just said Wexford County, I'm actually taking up a Missaukee County case. Case number is 25-3642 FH. Joining me via Zoom from the courtroom. Appearances, please, beginning with the prosecutor.
Thank you, David, and on behalf of the people.
Robert Hartel for Miss Brown, who joins us also by Zoom from the county jail, Your Honor.
Thank you. Miss Brown, are you able to see and hear the court?
Yes.
Thank you. Also joining me there in the courtroom, I can see Miss Laura Odell, who is the probation officer from the Michigan Department of Corrections and appears as well. We are here today, Miss Brown, for a arraignment on a request and warrant for a probation violation. It includes 6 counts. I need to go over with you what those counts are, what your rights are, and your possible consequences, and then see how you wish to respond. Count 1 and count 2 each allege a violation of condition 2.4. That term or condition of your probation requires that you must not use or possess controlled substances. And more specifically, it's alleged that on or about March 28th of this year, you possessed methamphetamine for count 1 and ecstasy or MDMA for count 2. Count 3 alleges that you violated condition 9.2. That requires that you must not use any mind-altering substances, including recreational marijuana, and that on or about March 28th of 2026, you used marijuana and did not have a valid card. And again, as we mentioned last time, actually we're here today for a hearing, if I remember right. I'm sorry. Anyways, count 4 alleges that you violated condition 4.4 that requires that you must be in your approved residence between 11 p.m. and 6 a.m. And again, that on or about March 26th of 2026, you were out of your approved residence during curfew hours. And counts 5 and 6 allege that you violated condition 1 by violating the law. Criminal statute, more specifically for count 5, that on or about March 28th, you operated a motor vehicle where your license had been suspended, denied, or revoked. And again, count 6, that you operated a vehicle without insurance. We are here now to find out what's going on. Mr. Hartel?
Yes, thank you, Your Honor. After talking to my client and the people in the probation department, I believe we have a resolution in this file.
All right. And what do you think that resolution is, Mr. Hartel?
Yes, Your Honor. If I understand correctly, the resolution would be for my client to plead guilty to count 1 and count 5 to dismiss the other counts. The people would also be willing to agree not to charge any possible misdemeanor charges coming from the alleged driving violations.
Oh, but she's pleading guilty to one of the driving violations. Is that right?
As far as for purposes of violations in circuit court for probation.
All right. Yeah, all right. I got it. Thank you. Mr. Denout, is that correct?
That is correct, Your Honor. Just to reference, there was a case that was about to be filed that the defendant would have been arraigned on Monday. We'll be dismissing, having to do with the traffic stop that precipitated this, Your Honor.
All right. Thank you. Ms. Brown, is that how you wish to resolve this?
Yes, sir.
Please raise your right hand. Do you swear or affirm that the information and testimony that you're about to provide shall be the truth, the whole truth, and nothing but the truth?
Yes, sir.
You may lower your hand. Ms. Brown, do you need me to go over the offenses with which you are charged again?
Yes, sir.
I'm sorry, you want me to go over them again?
No, sir, sorry.
That's okay. That's okay. Now, I'm told today that you're going to plead guilty to 2 of them. One of them is count 1, which is the violation of condition 2.4 for the use of the controlled substance of methamphetamine. And count 5 is an allegation that you operated a vehicle while your license was suspended, denied, or revoked. Again, I'm told that you're going to plead guilty to those two. In exchange for that, the prosecutor is going to do two main things. Number one, he's not going to bring any new criminal charges that would be filed in the district court for any vehicle violations that may have occurred on or about March 28th of this year. Second, he is going to dismiss counts 2, 3, 4, and 6. So far, is that what you understood you were going to do today?
Yes, sir.
Now, by entering a plea of guilty to those two counts, you're not going to have a hearing of any kind. That means you'll be given up right to have the prosecutor prove the allegations by a preponderance of the evidence, the right to be presumed innocent until proven guilty, the right to question and cross-examine any witnesses against you, the right to have present witnesses, evidence, or testimony. Also, you'd be given up the right to remain silent and the right to not have that silence used against you. Do you understand that, Ms. Brown?
Yes, sir.
Also, if you are do plead guilty and the court accepts that plea, you'll be resentenced on your original offense. Again, originally in this case, you were convicted of lying to a police officer where the offense was punishable by 4 years or more, which is a felony punishable by, a high court misdemeanor punishable by up to 2 years and or up to $5,000. Is that what you understood, Ms. Brown?
Yes, sir.
And do you understand your rights and that by pleading guilty to the two, you're not going to have a hearing as I discussed?
Yes, sir.
Have there been any other promises, threats, inducements to force or compel you to make these two admissions today?
No, sir.
Has anyone made any statement or assertion to you as to exactly what the court would do for sentencing?
Yes, sir.
I'm sorry, they have?
Oh, no, sir.
All right, it's okay. Just got to ask you if you are. So, all right. Do you wish then to enter the pleas of guilty to those two counts?
Yes, sir.
As to count 1 and count 5, how do you plead?
Yes.
Before the court can accept that plea, I'm going to have you tell me what it is that you did that makes you guilty of that offense. Before asking any questions, the court takes judicial notice of the terms or conditions of probation that this court signed and that were subsequently acknowledged by you after the conviction. In this case, there was an original sentence done on February 27th. Ms. Brown, is it true that on or about the 28th of March, you had tested positive for methamphetamine because you had recently consumed or ingested or used methamphetamine?
Yes, sir.
And is it also true that on or about the 26th of this month, you were found to have been operating a motor vehicle on a public highway or place open to public driving while your license was suspended, denied, or revoked?
Yes, Your Honor.
And did you know that your license had been suspended, denied, or revoked at that time?
Yes, Your Honor.
Mr. Denhouten, are you satisfied with this testimony and statements by Ms. Brown?
Yes, Your Honor.
Mr. Hartel?
As am I, Your Honor.
Mr. Denhouten, are you aware of any other promises, threats, or inducements?
No, Your Honor.
Mr. Hartel?
No, Your Honor.
Denhouten, do you believe the court's compliance with the court rules thus far?
Yes, Your Honor.
And Mr. Hartel?
As do I, Your Honor.
Thank you. Court agrees and finds the defendant's pleas today to these two probation violations are made freely, knowingly, and voluntarily. The court further finds the testimony provided by the defendant under oath on the record satisfies the required elements of proof in this case. Therefore, she is found guilty of count 1 and count 5. Counts 3, 4, and 6 are hereby dismissed. Are we able to proceed to sentencing at this time, Ms. Odell?
We are, Your Honor.
Objection of that, Mr. Denhouten?
No objection, Your Honor.
Any objection, Mr. Hartel?
No, Your Honor. My client advised me she would prefer to proceed today if possible as well. Thank you.
Ms. Brown, you have the right to be physically present in the front of the court in person if you choose to do so. Or you can waive that right and allow us to conduct sentencing at this time. Do You waive that right?
Yes, sir, I do.
Thank you. All right, the court finds that the technology is appropriate for doing so, and we'll proceed. Ms. Odell, your recommendation.
Your Honor, Ms. Brown had originally been sentenced to 2 years probation and 150 days jail. That took place on February 27th of this year. At the time of her sentence, I had recommended a jail sentence only. Ms. Brown asked for probation, asked for the supervision, and the court granted that. But unfortunately, she was out of jail 2 days, and we now have her back in jail with new violation behavior. At this point, I just don't feel that supervision is beneficial to her. I've been supervising Ms. Brown for about 5 years. She had discharged from parole just a few months before committing the instant offense. And no disparagement to Ms. Brown. I sincerely want her to do better, but I don't feel like my services are helping her anymore. I feel like I've done all I can for her. So at this time, I would recommend that probation be discharged unsuccessfully and that a jail sentence be imposed. Guidelines are 2 to 17 months.
All right, thank you.
And she has 129 days of jail credit.
All right, thank you. Use 129. Got it. Thank you. Mr. Denham.
Thank you, Your Honor. I noted that in the PSI report, there was a recommendation at that time for a straight jail sentence. As Ms. Odell has noted, the defendant was out just a few days and these new violations occurred. Defendant is developing somewhat of a lengthy prior criminal history. I believe there's 16 now, 16 or 17 now convictions. And so we do believe that a straight jail sentence would be appropriate. And so, in short, we support the recommendation by the probation department. Your Honor.
Thank you. Before I turn to Mr. Hartel, Ms. Odell, was Ms. Brown on probation at the time the original offenses here occurred?
She was
you
not,
look
Your
at
Honor.
Oh.
She had discharged from parole just 3 or 4 months, I think, prior to this happening. But she was not under supervision at this time.
And am I correct in recalling that there had been some bond violations in this particular case?
Yes, there were several bond violations.
All right, thank you. Mr. Hartel?
Yes, thank you, Your Honor. I did meet with my client a couple times earlier today, and I do believe she will want to make a brief statement before the court sentences her, if the court would allow. Based on what she told me, she wanted to say, I believe that'd be appropriate. She has advised me that she does hope to be able to be a law-abiding citizen moving forward. She's realized that certain things are more triggers for her than others, including the fact that for some people, a change of scenery can make a lot bigger difference than maybe some people realize. She has come to that realization she needs to be around different people, different locations, different stimulus, just a complete reboot, basically. So even though normally I'd probably be asking the court to consider not giving her any additional jail, I'm instead going to ask the court, based on my conversations with her, to still terminate her probation, but to sentence her on the lowest possible end of those guidelines. We realize that's at the court's discretion. We realize there's no Killebrew, definitely no Cobbs, but I do believe that would be appropriate to give her that opportunity to do that fresh start. I do wish her nothing but the best. And again, I do believe she has a brief statement she would like to make. Thank you.
Thank you. Ms. Brown?
Your Honor, I've lost my mind. And when I walk out of here, whenever my sentence is over, I have to go to rehab. I can't just walk out of jail and think that I've got this. Like, I have no home to go to, I have no children to go to, I've lost everything in a matter of 3 weeks. I'm not asking you to send me home, but I'm asking you to give me a chance to relocate, to change my life. I can't do it here. I run just as fast as I could to get high, and I don't understand it, other than I've lost my mind. I have no excuse for my behavior. It was a drive. Once I had a choice, my choice was the wrong one. And I don't know how to change being arrogant and above the law.
Miss Odell, what was the offense for which she was sent to prison last?
That was for a possession of methamphetamine charge, Your Honor. She was originally placed on probation, had some violations, was sentenced to boot camp as a probationer, then violated again, ended up going to prison, and then paroled.
Okay. What was the prison sentence?
18 to 120 months, Your Honor. That happened on July 28th of 2023.
Thank you. Okay. The court includes herein by reference the rulings and comments and reasons for the original sentence stated on the record last time back on February 27th. I'm quite familiar with the case and the defendant, and as I think I'm able to show, I recognize that she had the prior prison terms. I know she had some drug issues. I know she's had some bond issues. And the request and comment of, well, she needs a different atmosphere with different stimuli. I don't know what that different atmosphere can be. Jail hasn't worked, probation hasn't worked, boot camp hasn't worked, prison hasn't worked. So it's getting to be where there really aren't too many choices. If I send her to prison on this, I could. I think she's starting to give us reasonable grounds. But I don't think that's going to work. So the court hereby finds, because we're at our wit's end here, and based upon her prior record or history or violations, the most reasonable proportionate sentence that I can think of giving at this time is as follows. The court reserves all fines and costs. The court terminates probation, and court sentences the defendant to a jail term of 330 days with 129 days of credit. That is within the guideline range. Also, while the guideline range is an intermediate sanction, the court finds reasonable grounds consistent with the basis for the sentence being reasonable and proportionate. All right, this Ms. Brown, you're going to receive there while you're at the jail 2 copies of your appellate right document. You're going to sign one or place your initials on one, merely acknowledging receipt to the other. And then you're going to, if you choose to file an application for leave to appeal and you want the court to appoint an attorney to assist you, you may complete the bottom half of the other copy that you will take with you and return to the court within 42 days. If you choose not to appeal, you may simply dispose of your copy of the document. Ms. Brown, I'm really disappointed here in seeing you here again today. I really had hoped for the best, but I'm telling you, it's all up to you from here on out. And I really am gonna feel bad if I find out that you overdose by your drug use. I don't know what more I can do. All right, that's the sentence of the court. Anything further, Miss Odell?
No, Your Honor, thank you.
Mr. Denhoughton
No, Your Honor, thank you.
and Mr. Hartel.
No, thank you, Your Honor.
Thank you.